Hello, my name is Stephen Labiak, and welcome to this week's talk about bankruptcy. This week we're going to talk about kind of a special situation that not a lot of people run into, but it is out there. We're going to talk about class action lawsuits. Now, for most people, you're involved in a class action lawsuit. It's going to be considered an asset of the bankruptcy. Most people, when you settle in a class action lawsuit, you're getting $5,000, $10,000. So you list that amount on your bankruptcy forms. And most people, you can cover it under the 703 exemptions. It's part of your wild card, and you move on. However, if you're involved in a medical lawsuit and they give you, let's say, well, the attorney tells you, I think you're going to get $10,000 out of this. Well, great. What if the attorney's wrong? Typically, maybe not typically, but what can happen especially in medical lawsuits or severe personal injury, class action lawsuits, is the attorney may give you an estimate of $10,000, but maybe it's worth $100,000 at the end of the day. But the problem is you may not find out for 5, 10 years down the road what your claim is actually worth. Your problem is well, you said at the time you filed bankruptcy it was worth $10,000. If you end up getting $100,000, what do you do? Well, a good trustee will address this at the 341 meeting. But make sure your attorney is aware of it also, and he explains it to you. What you do in this kind of situation, so your case is not open for 5 to 10 years waiting for this money to come through, is you merely stipulate that your claim is worth what you listed it at. So you said it's worth $10,000, it's worth $10,000, you stipulate to that. And then you also stipulate that if you receive more, you will inform your attorney, and your attorney will inform the trustee. What a stipulation is an agreement between the parties in the case. So you agree to tell your attorney agrees to tell the trustee. What this does, it allows your case to be closed, it allows you to move on through your life, but it also allows the trustee, in case you do end up basically getting a windfall, to reopen your case, and that money will be turned over to your creditors. Now, I know you may not think it's fair that the trustee gets the money and it's been 10 years, but at the end of the day, if you put down it was worth $10,000 and it's worth $100,000, well, that's a pre-petition asset, even though you got it 10 years later. So it's just kind of one of those special cases to be aware of. If you think it's a concern, talk to your attorney about it. If they don't know what I'm talking about, I'd get another attorney. So give me a call at 559-274-2868. I'll be more than happy to speak to you about this or any other bankruptcy issue. Thank you.